Hi, I'm John Cannon with Cannon Associates, your fierce advocates. I want to thank you for joining us for another live Q&A session to address your questions and your concerns about divorce process, assets, child support, alimony, and really all the financial issues that come into play during the divorce process. I want to thank you for submitting your questions to us today. I hope that I can cover each of them during this call. And if you have any other questions or issues, please submit them so that we can address them during this video or during a future video. So I'm going to jump right into the first question that we received today. First off, what happens to alimony and child support if I remarry? Many people enter into the divorce process, and when the case is resolved, they find themselves either receiving or paying alimony. Alimony is basically the way that one spouse provides temporary or long-term financial support to the other spouse. Typically, in divorce cases, if one spouse is the dependent or the homemaker or does not have financial independence from the other spouse that's the primary earner in the home, then that dependent spouse will receive support alimony or financial support from their previous spouse for a period of time after the case. Now, there's really two primary forms of this. One is transitional alimony, and one is support alimony. Transitional alimony is the concept that a person needs time to re-enter the workforce or time to become financially stable enough to be financially independent from their spouse. This type of alimony is pretty common in Oklahoma, especially with one spouse being the stay-at-home parent or not working outside of the home. Conversely, support alimony is the idea behind one spouse being dependent upon the financial support of their now previous spouse. In these cases, support alimony may be ordered permanently or for a longer period of time, such as 3 or 5 years, to give a person even more time to become financially stable. We often get questions by former clients of what happens when my divorce, we often get the question of, if I've been divorced and I get remarried, will I still receive support alimony? Or if my spouse gets remarried, will I still be obligated to pay them spouse support? And the answer is typically no. Unfortunately, all things in the law live in some form of the gray area. And so when it comes to the question of support alimony, sometimes the issue is a maybe. And so if you are the spouse that's been paying support alimony while the divorce is pending and after the divorce as part of your divorce decree, you may be able to stop paying spouse support altogether if your spouse remarries. The default is that a spouse is only entitled to receive compensation in the form of alimony from their previous spouse while they remain unmarried. But there are circumstances that can be different. If there's a court order or agreement by the parties that it will extend beyond one party remarrying, then that can be enforced. Additionally, there are circumstances where a person will receive a portion of a retirement account that is paid out in a monthly increment or other financial interests that are paid monthly installments. Those interests remain beyond a spouse remarrying. So it's important recognizing that there's different types of alimony and different ways that financial support can be provided. If you're the dependent spouse, it's important that you ensure that you have put yourself in a situation where you will be financially secure after divorce, and in some circumstances, find a way for you to continue being financially secure if you remarry. And that's something that's important to discuss with your family law attorney to make sure that your financial interests are protected. Conversely, if you have been the spouse that's the primary earner that makes more of the money, that has the job outside of the home, or makes significantly more money outside the home than your spouse who maybe had a job that provided less income to the household, then you may find yourself in a situation where you are paying support alimony or transitional support after the marriage in the form of alimony. If your former spouse is to remarry, in most circumstances, that will allow you to cut off paying support or continue paying support. And it's important to make sure that all of the factors, the conditions that have to occur to make you eligible to stop paying support have taken place before you stop making those payments. And that's something you can do by speaking to the family law attorney that you worked with in your initial case, or by scheduling a paid consult with a family law attorney or family law firm that you know, like, and trust, that can look at the divorce decree, that can hear from you what the circumstances are for the parties at this time, and give you legal advice on whether or not you can stop paying support alimony. Now, it may be a slight investment of a few hours of billable time by a family law attorney to get answers to those important questions, but I can assure you it's better than the alternative. Because if you elect to just stop paying support alimony, the other party can do a number of things. One, they can hire their original family law attorney, or they can hire a new family law attorney and potentially bring you to court. They can file a motion to enforce the divorce decree, a motion to enforce support alimony, and that may obligate you to appear back in court or hire a family law attorney substantively to contest that issue for you. I know the family law attorneys aren't cheap, but we do bring knowledge and experience that can help you through these difficult and complicated circumstances. But I can assure you that working with your previous family law attorney or investing in a couple of hours of legal time to speak to an experienced family law attorney to get answers to the question about spousal support before you stop payments is a better investment than the risk of being held back to court and having to hire a full-blown legal team in order to fight an issue of support alimony or contest a motion to enforce. So a big takeaway on this point is that it's always best for you to get a legal opinion to make sure you're safe before you stop making support alimony payments. And it's also important to get legal advice before you assume that your remarrying is going to allow you to continue receiving spousal support or not. Next, one of the most common questions we get is, if my spouse remarries, do I have to keep paying them child support? And the answer is yes. It's important to keep in mind that our statutes and the theory behind child support, whether you agree with it or not, is that child support is the child's payment for their share of maintenance of a home. So stated another way, it's basically the child's rent, or they're putting money into the pot to pay for their portion of how much it costs to run that household. So many child custody arrangements have one parent who's the primary, who that child will spend 18, 20, or even more days a month in that home. So the other parent has a few weekends, a week during the middle, a night during the middle of the week, but somewhere in that 6 to 8 evenings a month. In that circumstance, the child is living with and is a financial obligation on the other home the vast majority of the time. And so in those circumstances, the child will have child support payments that go towards the primary household that may be significant. It's important to keep in mind, even if that person remarries, it does not necessarily change your child support obligation, because the child's impact on that home is not necessarily decreased. Now, yes, when your former spouse remarries, it may mean that now, as opposed to one, there's two incomes that are supporting that one household. However, the child's impact and expense for the child on that home may not decrease at all. So you can certainly speak to a family law attorney and get answers to your questions about, can I move to modify child support? There's certainly a process through DHS where administratively you go to DHS and seek to have child support reduced. But you're also entitled to hire an attorney or on your own, which I'd advise against. It's always best to have a lawyer if you have a legal issue. You wouldn't want to operate on yourself, so you should hire a doctor if you're sick. But if you have a child support issue that you want to address, speak to a qualified family law attorney, bring them your questions, get answers that have experience behind them, and you may have a basis to file a motion to modify child support. And with that, again, you're presenting the facts that are relevant and submitting your own calculation through the child support computation on what you think child support should be amended to. And that can change based on your income, your spouse's income changing, and many other factors that play a role in how child support is supposed to be calculated. So remarriage does not necessarily impact or reduce your child support obligation. Getting remarried yourself does not mean that you will stop receiving or get more child support than you had before. But all of these things operate together. It's like a big pool. If you drop something in the water here, it may or may not have a ripple effect on the opposite end of the pool. And so you're certainly entitled to speak with a qualified attorney. And I would encourage you to do that in your state, whether you're in Oklahoma or beyond, before you make important decisions about, of your own choice, stopping child support or reducing your payments, or stopping alimony or expecting for it to continue. Because the alternative is being held into court and a judge telling you that you broke the court's order and potentially not only paying your attorney fees, but potentially the other side's attorney fees, as you may have forced them to come to court to address this problem. Another common question that we asked is, will my credit score be affected by my divorce? Now, this is kind of a loaded question because just in the vacuum of divorce itself, it should not impact your credit score. However, there are lots of things that happen during especially contested divorces that can have an impact on your credit score. If you have to get a new vehicle, if you rack up credit card debt with legal fees and other expenses during the process, if you have to rent a new home or purchase a new home, if you get a new vehicle or additional vehicles, if you have other financial things that occur during the course of the divorce, those things can have an impact on your credit score. So when you work with an experienced family law attorney, they can help you to not only strategize the divorce process itself, but help you to structure your personal finances in a way that you're not exposing yourself to any grave risk in the divorce process, but also help you to stop exposing yourself financially from having a negative credit impact during the process by some type of financial decision you do or do not make during the process. Here at Cannon Associates, we try our best to not only advise people about the impacts of divorce for themselves, for their children, but also how this will impact their finances, not just now, but far into the future. Many of our clients have been married for 5, 10, 15, 20 years. And so that life that people have built together, when it's divided, it has serious impacts on your finances. But there are ways that you can structure things over time through a qualified domestic relation order or a quadro, through a division of assets, and other financial tools that exist in the divorce process through financial advisors, through the financial system to mitigate the negative impact, to reduce your new exposure to tax liabilities, and to also reduce the chance of having a negative credit impact based on all these different things that are moving and changing and accounts being transferred or open or closed during the process of a divorce. How much child support will I have to pay? Unfortunately, this is $1 million question that has to be answered in each individual case. But like I was speaking about a moment ago, child support really comes down to what is the financial implication of that child being in a home. Now, when the child is in the home 50% and exactly 50% on the other side, that child support calculation may be next to nothing. And also the parties can sometimes waive child support in lieu of other things in the process, or that payment be reserved and calculated some other way. But the amount of child support, the biggest factor is the number of overnights. So if we take your average month that is 28 to 31 days, how many nights that child spends in one home, or the percentage of overnights, plays a direct role in how much child support will be. And so if you're seeking to reduce your child support obligation, if your child or children spend more nights with you than with your spouse, or if the child spends more nights with you than the other parent in a paternity case, a custody case, then that will likely result in you not being the one obligated to pay child support. Now, if you know that you're going to end up being the parent that has fewer overnights, by stacking those overnights up, that can directly reduce the amount of child support that you will pay. Because the presumption is if that child is spending 10, 12, 14, 15 days 10, 12, 14, 15 nights a month in your home, that child is an equal financial obligation on your household as they are on the other person's household, or very close. And so if you're in a situation where you can get 10 or 12 overnights a month, as opposed to only 5 or 6, that will reduce your child support obligation to provide for that child spending more than 60, 70% of the month overnights in the other parent's home. Now, other factors to consider is income. And I know that you can't necessarily directly impact your income, but you can ensure that you're properly documenting all sources of income for your spouse or the other parent, and ensuring that all things that can be used to calculate deductions or reductions in your income are applied. Because one of the other big factors in child support computations is the income of the two parties. Now, there are many other factors that impact this, which you can get into through the child support computation calculator. Oklahoma is one of many states that has a very good system of inputting all of the facts or data points to determine an initial child support calculation, but it is a science as well. And so when you work with an experienced attorney, they can help to ensure that all the things that can point in your favor or document on your side are inputted correctly. So when you go to court, either for an agreed child support calculation or a contested hearing where the judge is going to decide what calculation they will use, it's important to be prepared and be able to explain and present evidence to support the child support calculation that you have done with your lawyer. But if you're bored on a Thursday night, you can get online and go plug in information to that child support calculator to get an estimate of what it would be in your case. But keep in mind that your initial rough draft, without really diving into the issues and necessarily understanding all of them, may be inaccurate. And so it's important to know that you need to work with an experienced family law attorney to make sure that you have a fair assessment of what child support calculations may be so that you're prepared for what the road is ahead. Another common question we get is, what happens if my ex-spouse is unemployed? Your ex-spouse being unemployed will impact your finances. Now, the good thing to keep in mind is that during the divorce process, you can set things up to where that impact will largely be cut off after the divorce is finalized. You can set up finances, which we do for many of our clients, where they would provide an asset to their dependent spouse, and they would receive a portion or incremental payments from that asset over a period of time, so that this entire entity or this entire investment account, 401k portfolio is given to the dependent spouse, and it provides them incremental monthly payments so that they have that financial stability for a period of time. It also allows you to completely cut ties with your former spouse or the dependent spouse by maintaining the entirety of these other assets or accounts that you keep. And so that's something that we try and do, is look at the total financial picture, the financial portfolio in the marriage itself, and then try and identify a way that you can separate accounts completely. So this person receives all of this, I or you receive all of that, and set it up so that there's not a mishmash. It reduces the fuzzy area, the gray in the process. So if your spouse has been unemployed, you will likely be required, either by agreement or by court order, to provide transitional support for a period of time or long-time support to ensure that they are not on the street, homeless, destitute. But you can often, especially in Oklahoma, that favors transitional support, like a person becoming reemployed if they're at the age that they should be able to have medical conditions or medical situation, health situation that allows them to be reemployed. Oftentimes you can set things up to where that support alimony will terminate at some date. You can set up the division of accounts to where all of your financial ties to that person will end at some point in time. Now, an important caveat or footnote or asterisk to that, as there always is in family law, is that if there are 401k, retirement accounts, pensions, military pension, all of these different prospective future interests, if it turns out that that's decided by agreement or by the court that that's a marital asset, or that your spouse is going to receive a portion of that, then that will to some extent have you continue to be tied financially to your former spouse. But the important caveat is that if you draft, or if your attorney, not you, please do not draft on your own. If you have a qualified domestic relations order or a quadro that divides an unrealized or future interest or future asset, such as you pay into Social Security now, but you may not receive it until far in the future. Those types of future assets, if you can't access them now, the quadro allows you to divide it. It's given to that financial institution, and at the appropriate time, they will divide it accordingly and give your spouse their marital share, whatever is decided upon by the parties or by operation of law. So you can, for the greatest extent of your financial interest, completely divide your connection to your spouse at the date that the divorce decree is finalized. But some things do linger, especially when accounts are piecemeal, where they get a portion of this and you get the remainder, or they get the majority and you get the remainder of account. If you have concerns about financial ties to your spouse beyond the divorce process, it's really, really important that you make the investment to work with a family law attorney that has experience on these assets, especially higher value assets, because the complexity of how people's financial portfolios can be set up is incredibly complex. And so the types of assets that you have now or will realize in the future, including real estate, investments, all of these different things, interest in a property or mineral interest. All of these things are important to consider before you finalize the process, because once the ink is dried and that document is filed in a divorce decree, it is very, very difficult to go back in the future, go back down the road in time and correct something that was done inappropriately that negatively impacts your financial future. So make the investment, work with a qualified family law attorney wherever you are in the country to make sure you're protecting yourself as not only the higher earning spouse, but the dependent spouse as well. What are my options if the other parent isn't paying child support? This is unfortunately a very common question and a very common problem in the family court process. So again, there's really three ways that you can go about addressing child support shortages and payment. The first and hopefully the easiest way to address it is if the divorce is pending, is by telling your lawyer they'll contact the other party's attorney and get it resolved by agreement without the expense or the time of going to court. Uh, Once the divorce process is over, before you have to hire a lawyer, there's really three important things to consider. One is you can contact the other party, remind them of the court order, and tell them what's going to happen if they don't take care of it. I've found many times that our clients are able to resolve these issues just by putting that in a text or an email or documenting it so that they have that record later on. Second, DHS has a vested interest in the welfare of children across the state, in any state, whether they are in foster care, whether they are in the system, whether they are in a family, in a home. And so you can get DHS involved to ensure that someone is paying their child support obligation. And DHS has a lot of power in the state to not only compel that person to answer, but also the ability to take money out of people's pay directly to ensure that those obligations are met. That's called a garnishment. And it goes one step further. If DHS issues a garnishment on someone and that business or that individual person that owes child support refuses to pay, then they can take future legal action against that person for violating the court order, including fines, penalties, even jail time in some circumstances. And the third and final way is you can take them to court. That is the most expensive and also the most direct way to address the issue. You can file a motion to enforce. So if there's a court order for child support and someone's not abiding by it, you can file a motion to enforce, where you're telling the court, this was a previous order that you made or we agreed to, Your Honor, and this person is supposed to do this, pay this exact amount of child support on these exact dates, and they're not doing it. And I ask that you enforce that. You file that, you serve the other party, you get a hearing date in front of the judge, and then you serve that person with a court date. And they're obligated to appear and answer. Now, a lot of times that issue gets resolved by the person getting in compliance and making up their delinquent child support payments or their arrears in child support before that date. But if not, if you show up in front of the court and you've done things appropriately and filed the proper paperwork and documented the lack of payment and have the bank records to show that, then the court is likely going to enter an order against that person. If they don't fix it now, they may find themselves in jail for direct contempt by not following that court's order. So do not just suffer through not paying, do not just suffer through not receiving child support that's been ordered. Take one of these steps in order to rectify that issue, not for yourself per se, but for your child. I'm a father, and I'm happy to say that currently my wife and I are happily married. But if things were to change, or in family dynamics I know where those things change, it's important that child be supported by both parents, even if they're not in the same home. So you owe it to yourself, but more importantly to your child or children, to ensure that the other parent that is responsible for helping to ease the financial strain of having your child or your children in your home more often than not is paying their share. And so use the system and the tools available to do that. Again, do not take justice in your own hands. Use the system. There's lots of tools available to address that issue. How much spousal support can I expect to receive and for how long? This is a little bit of a rehash of the conversation we had a moment ago, but the amount of spouse support is partially based on the lifestyle that you and your former spouse, or as you're going through the divorce process, your current spouse have been living. So if you've been living this type of monthly expense lifestyle and all the things that go along with it, country club, eating out, vacations, luxury travel, luxury expenses, shopping on a regular basis, all of these things then the court may enforce that person maintain that type of lifestyle for you during the divorce process and beyond. Conversely, if you've been living a more conservative lifestyle, eating at home more often than not, rarely if ever shopping, if you go on vacations, there's simple road trips to locations that are reasonably expensive, then the court is most likely going to continue to enforce that type of lifestyle be provided for you. So it's not so much that people that live a more expensive lifestyle get it better in divorce. It's that the court is going to try and maintain the lifestyle of everyone in the process and potentially beyond the divorce itself. Now, how long will this last? That is another key question. It really varies by the court. One of the principles for support alimony or alimony in general, at least under Oklahoma law, is that it's really a two-pronged analysis. First, is there a need for support? And second, is there an ability to pay or provide support? So let's turn to that first question. Is there a need? When someone has been the dependent spouse, where they are solely financially dependent on their spouse, there will at least be a period of time where that spouse is financially dependent on their spouse during the divorce process and potentially beyond it. If one spouse has earned less money than their other spouse, then they've contributed less than 50%, at least financially, to the home on a monthly basis. And so in those instances, again, the court will typically order, or the parties will agree, for some period of support to allow that person the time to be employed in a way with a higher earning capacity, potentially go back to school to receive more training or education, potentially to get some certifications or skills that allow them to receive a higher paying salary or get into a job that may be more demanding time-wise, but also provides them with greater financial compensation. But either way, whether the lower earning income spouse or the spouse that earns no income outside of the home, typically there'll be some period of transitional support alimony for that person. So the amount is largely based on the lifestyle of the parties beforehand. A family where the couple were spending, say, $2,000 to $3,000 a month, that spouse will likely receive a much smaller amount of transitional support or support alimony in general than a household where the family was spending $10,000, $15,000 a month, because the court will maintain some level of semblance for the dependent spouse during the divorce process and after the divorce process. Now, one final thought on that is the length of time. Again, in Oklahoma, most courts presume that support alimony is transitional, or transitioning from being the dependent spouse or the lower income earning spouse to being independent again as a single parent or as a single person if there aren't children in the home. That is the norm, but there are many instances where the parties will either agree or the court will order that one spouse is going to have some level of need or the complete level of need of financial support for a very long period of time. And so it's very important that you speak with your family law attorney, vet family law attorneys in the process, because we know that spouse support is a key issue for both sides of the marriage. And it's important that your interests and your rights are protected and that you know it may lay ahead in your case. We have a lot of joint debt. How will this be divided? Now, debt is one of those things that it's again an evaluation of, do we have it, or do I have it, or do you as my spouse have it? Oklahoma is a property state that deals with marital versus private property. And so if a debt is a marital debt, then it will have to be divided for or accounted for on a marital balance sheet, balancing debts and assets and incomes between the two sides of the marriage, versus a privately held debt or a separate debt. For instance, if someone were to go to college before the marriage took place and that person accumulated some or substantial amount of student debt during their education process, that is typically that person's separate debt, and they would be obligated to it beyond the marriage. However, the parties can contract for nearly anything. And so how debt is divided is similar to how our assets divided. First off, can the parties reach an agreement for how they're going to divide the stuff? And the stuff does include the bad stuff, the debt, but it also includes real property assets like your home, vehicles, investment accounts, property, pensions, 401ks, the china, your favorite tools, your spouse's personal assets or personal effects. All of these things must be divided during the divorce process in that marital balance sheet. And so debts division, first and foremost, depends on its classification. And that can be very contested, or it can be by agreement that all of these items of debt, we can agree on that they're marital debts or they're not marital debts. If it's agreed upon, it makes it much easier to divide them and balance them in that marital balance sheet against marital assets. However, if these points are in contention, then that can lead to litigation on it, whether it's the parties going to court, having hearings about those issues, an actual trial where there's an issue, a final judgment on that factual or legal issue by a judge on how that debt should be classified, to determine if it's his or hers, or hers or hers, or his or his. It's an important point. Again, I'm not trying to be a parrot and just going the same thing over and over again, but it's important you work with an experienced family law firm so that they can help explain in simple terms that you understand, that you can apply in your facts of your case for how marital debt is determined, how separate debt is determined, and what can happen either by agreement or by contesting it to divide that debt during the process or in a final agreed divorce decree, or alternatively in a divorce trial where the judge decides how that debt will be allocated. How can I protect my inheritance or premarital assets? This is kind of the converse of that inheritance, as long as it's not commingled or shared in such a way that you can't distinguish it from marital assets. If there's not that commingling or muddying the waters of the asset so much that it can't be determined, then premarital assets and inheritance are separate property. And so being a marital property state means that some stuff doesn't automatically become marital property. And so if you have an inheritance, even if there's not a prenuptial agreement in your case, then that may be an asset that is yours separately from your spouse. I don't see any other questions currently, so I think I'm going to wrap it up with that. But I would encourage you to reach out to us if you have any questions. You can visit our website, www.jpcannonlawfirm.com. You can also get our book on the website or on Amazon, Informed Divorce. It should have answers to many of your questions for facing divorce, whether in Oklahoma or anywhere in the country. And if you have any specific questions, please reach out to us or to Spirit's family law attorney in your jurisdiction. Our goal is to get answers to you. I know many great family law attorneys across the country, and they have built a career as we have at Cannon Associates to serve and try and help you through this difficult time. I hope that this video has helped you on your path towards your better future of getting through the divorce process. And we encourage you to get answers to your questions, because knowledge is power through the process. And there's nothing worse than not knowing what you're facing and not knowing what you do in your divorce case.